Question is the motion be agreed to. Paul, the member for Chisholm.
Thank you, Deputy Speaker. I rise today to talk to this motion moved by the member for Newcastle. It's a pity the member for Lindsay reflects negatively on the work of the Joint Bipartisan Committee and refers to faux empathy. Indeed, the Bipartisan Committee, a joint House committee, made several recommendations based on submissions by members of the public and others who had given of their own time. In my early days as a young lawyer, I practiced family law and saw firsthand that often divorces, breakups are inherently serious and complex when the element of domestic violence is an integral component, and that sadly, domestic violence implicated with the family law proceedings often has significant devastating consequences for the victims of violence. Domestic and family violence has far-reaching effects for the women who are experiencing it and the children, and for women, including their disruption to their ability to work. The Australian Government recognises the important role that employers can play for employees experiencing domestic and family violence. Coming from 20 years' experience in the private sector, the manufacturing sector, employers always provided support during difficult times, and indeed the government encourages all employers to support their staff during such difficult times. Under the National Employment Standards of the Fair Work Act, employees already have the right to request flexible working arrangements if they are experiencing family violence or providing care or support to a member of their family or household who is experiencing family violence. The Fair Work Act includes general protections and up to 10 days of paid personal leave for employees of a family household member to recover from personal injury, including as a result of domestic violence. Contrary to Labor's claims, the government workplace bargaining policy does not require Commonwealth Public Service agencies to remove leave provisions for employees affected by domestic or family violence. It is of no help to victims of domestic violence to suggest this support will be diminished. These claims are inaccurate and dishonest and falsely create fear, even more fear, among the employees on this highly sensitive issue. Agencies are strongly encouraged to use existing provisions to provide support for employees affected by domestic family violence, and a number of Australian public service agreements contain specific references. Agencies whose enterprise agreements do not specifically mention leave for domestic violence remain committed to provide support for employees through existing arrangements. The Fair Work is currently hearing a case on the inclusion of domestic violence in modern awards, and the government will consider its position when the Fair Work Commission has made its decision. The government will consider its position once the Fair Work has made the decision. They've made a preliminary decision, and we will consider that. I rise to talk to this motion also, Deputy Speaker, as I see it as an opportunity to discuss the excellent work done in 2017 by the Social, Policy and Legal Affairs Committee, a bipartisan committee, and under the excellent leadership of the chair of the committee, the member for Corangamite. And may I take this opportunity to thank all those who made submissions in relation to this inquiry. I'm very proud that in March 2017 the Attorney-General requested that the House of Representatives Standing Committee inquire into how Australia's family law system can better support and protect those affected by family violence. Many families across Australia access the family law system for assistance and support to resolve the legal issues which arise following the family breakdown, and many of these families have had experience with family violence. It is imperative that adequate support and management is provided to these families to ensure their ongoing safety and well-being. The report represents the findings of the inquiry, including the difficulties posed by an adversarial family law system, the existence of inappropriate responses to family law system, the legal fees and complex court procedures, and the complexity of navigating state, territory and federal jurisdictions. Responding to these concerns, the report outlines various ways in which the family law system can be improved, including a nationally developed risk assessment tool and a stronger, more unifying approach to identifying and responding to family violence in family dispute resolution using the new nationally consistent risk assessment tool. Noted in the report are the early signs of success of the Australian Government's new Family Advocacy and Support Services program, and recommends the extension of this program subject to a positive evaluation, including into regional Australia. And once the matter reaches court, the committee makes several recommendations to ensure that the determination of family violence occurs in early proceedings, and that the complexity of family court proceedings are ameliorated. So I submit this and again congratulate the member for Corangamite for leading an excellent inquiry and making recommendations which will make the world a better place for the victims of domestic violence.